This case concerns a large-scale armed conflict with tragic consequences for civilians on both sides. Yes, there is a heart-wrenching armed conflict, but the attempt to classify it as genocide and trigger provisional measures is not just unfounded in law. It has far-reaching and negative implications that extend well beyond the case before you. Ultimately, entertaining the applicant's request will not strengthen the commitment to prevent and punish genocide, but weaken it. It will turn an instrument adopted by the international community to prevent horrors of the kind that shocked the conscience of humanity during the Holocaust into a weapon in the hands of terrorist groups who have no regard for humanity or for the law. If every resort to force in self-defense against an enemy hiding behind civilians can be portrayed as genocide and trigger provisional measures, an inevitable tension will be created between the Genocide Convention and states defending themselves against the ever-increasing capacities of terrorist organizations. Doing so would also signal to terrorist organizations that they can commit war crimes and crimes against humanity and then exploit this court to obtain protection. For us, provisional measures would lead to a perverse situation. It would effectively allow Hamas to continue attacking the citizens of Israel, to hold 136 hostages in unbearable conditions, to keep tens of thousands of displaced Israelis from returning to their homes, and essentially to promote its plan to massacre as many Israelis and Jews as it can. Madam President, members of the court, in living memory of the atrocities that gave birth to the term genocide, in the aftermath of which the State of Israel was founded, we are witness to a concerted and cynical effort to pervert the meaning of the term genocide itself. The Genocide Convention is too important a foundation in humanity's aspiration to defeat barbarism and evil to be belittled in this way. And the faith that has been placed in international law and its institutions is too cherished an asset to be squandered. We appeal to this court not to be taken down that dangerous road. Madam President, members of the court, for all the above reasons, Israel requests the court, in accordance with Article 60, paragraph 2 of the rules of the court, for the reasons given during the hearing of January 12, 2024, and any other reasons the court might deem appropriate. 1, to reject the request for the indication of provisional measures submitted by the applicant. 2, to remove the case from its list. Madam President and members of the court, that concludes Israel's observations. Thank you for your kind attention.